Hello and welcome to the EDRM Global Webinar Channel. My name's Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner eDiscovery today called Important eDiscovery Case Law Decisions for May of 2024. We welcome your questions and feedback in the console. Questions will be answered both during and at the end of the webinar. And this webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. Kaylee Wallstad, EDRM's Chief Strategy Officer, is here. Kaylee, can you please tell us what resources are available today?
Absolutely. And as always, I count down the days for one of my most favorite monthly series. I cannot wait to learn about the new case law. So we are loving ON24 with so many more ways for you, our audience, to engage. If you check out your console to the right of the screen, you'll see the question mark icon. This is where you can type in your questions for today's faculty, and we highly encourage you to do so. Slides will be made available after the webinar has concluded, and you'll see the paperclip icon for related content. If you click on it, you'll see today's resources carefully curated just for you. An ON24 Engagement Tools Descriptions PDF for you to download to help you better engage with the platform. You can click the link to subscribe to eDiscovery Today blog and never miss a thing. It's my favorite way to start the day. Thanks, Doug. A link to learn more about the Honorable Judge Peck and how to engage with him. And a link to order your copy of Tom O'Connor's spicy new book, eDiscovery for the Rest of Us, recently updated in a collaboration with EDRM's trusted partner, NextPoint. And be sure to secure your seat for next month's Case Law Edition on June 17th. And up next on EDRM's webinar channel, June 6th, Building the Case. Get buy-in to minimize data across your organization. Speaker bios can be clicked and popped up to learn more about today's faculty. And then just like Zoom, one of our favorite features, you'll see the smiley face emoji. And if you click it, there are many more reactions that we encourage you to click on during the webinar. We're having a lot of fun with them on this platform. You can give it a try now. And then if you click the Twitter bird for social media, you can follow EDRM and eDiscovery Today on LinkedIn. Back to you, Mary.
Thanks, Kaylee. And Doug Austin, he is the founder and editor of EDRM Trusted Partner eDiscovery Today. He's an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has published a daily blog since 2010 and has earned J.D. Super Awards 3 times. Tom O'Connor, affectionately known as Tom O, is the director of the Gulf Coast Legal Technology Center. He is a nationally known consultant, speaker, and writer in the area of computerized litigation support systems. Tom's consulting experience is primarily in complex litigation matters where he's worked with firms of all sizes, most recently the plaintiffs in the BP litigation. He's also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. And as Kaylee noted, his most recent edition of his popular book, eDiscovery for the Rest of Us, was launched at Legal Week with EDRM's trusted partner, NextPoint. And the Honorable Judge Andrew Peck is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters and also serves as a resource for the firm and its clients on litigation strategy and eDiscovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years, writing many of our first eDiscovery opinions, and then later on, of course, boilerplate objections, 502D orders, and I think we'll have a citing, and technology-assisted review. EDRM is grateful to all 3 gentlemen for their service on the EDRM Global Advisory Council. And without further ado, Doug Austin, you've got some cases here, don't we?
We do indeed, Mary, and welcome everybody to our May 2024 Case Law webinar on the EDRM network. This all-human panel does indeed have another six cases to discuss this month, and once again, 4 of those cases were suggested by our own Judge Andrew Peck. The cases that we'll be discussing address disputes related to prolonged lack of cooperation and discovery, Fifth Amendment protection of information regarding devices, dismissal of the case over intentional spoliation of ESI, request for social media usernames in OpenAI copyright case, and not one, but 2 cases regarding hyperlinked files, modern attachments, cloud attachments, or whatever you want to call them. As a reminder, we do welcome questions, and we'll try to get to as many as we can. And we'll send a copy of the slides out after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Unlike some judges issuing case law rulings, we don't issue disclaimers and then take them back a year later.
Ouch.
That's true. Before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistant site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 36,100 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So, with that said, let's get into the cases. Judge Andrew Peck may have taught us all what Rule 1.1 is, but one of our favorite judges, Illinois Magistrate Judge Jeffrey Cole, may be one of the best there is in illustrating that rule. In this case, which was suggested by Judge Peck, Judge Cole, frustrated with the lack of cooperation, wasted no time in illustrating that frustration, stating, "It is well to remember at this point in this long, contentious litigation that this is, at least on one level, a seemingly uncomplicated case about whether truckers entering the defendant's Illinois facilities put their thumbs into gate access scanners for identification purposes and whether they did so consensually. As this case moved into its 5th year, the parties did not meet another fact discovery deadline, a deadline they had selected. It was the 6th one they had missed, and at their behest, discovery was extended a final time for another 45 days to April 15th, 2024. We don't know everything the parties have been doing with that extra time, but we do know that it has allowed them an opportunity to bring another discovery dispute to court. Actually, it allowed them the opportunity to bring 2 more discovery disputes to court, because no sooner had they finished briefing this one, they got into another one involving a deposition. The return on investment of granting discovery extensions has been disappointing, to say the least. So Judge Cole in this case ruled on 3 disputes. On the first one, he denied the plaintiff's motion, stating the defendant clearly denied the plaintiff's request regarding whether the defendant admitted that it did not obtain plaintiff David Fleury's informed written consent to collect his biometrics. Judge Cole denied the second one as well, ruling that sharing 11 documents with third parties did not waive privilege, as the legal advice in this case has to be informed by individuals whose expertise falls outside the realm of motions to compel discovery. On the third dispute, Judge Cole ordered the defendant to compile a privilege log, noting that the defendant cannot simply make a blanket claim of common interest doctrine applicability, as the defendant is attempting to do here. It must instead assert the common interest doctrine on a document-by-document basis, as it is limited to those documents that fall within that interest. So, Tom, in the second dispute, Judge Cole ruled that sharing the documents with experts was allowed without waiving the privilege, as their expertise was informing the legal advice. So what do parties need to do to demonstrate that shared documents fall into that category?
Well, I think the judge laid it out pretty well. It has to be something that's sufficiently technical, that it's outside the expertise of the attorneys to do legal motions. In this case, he said these were, quote, complicated systems, and how they work and affected the shipping and security logistics were essential. So it's pretty straightforward. It has to be some sort of technical situation where you need to understand it in order to plead it, but you, the lawyers, don't have the technical expertise sufficiently yourself, so you're allowed to bring in people who do to act as your assistants.
Certainly makes sense.
Pretty straightforward, right?
Sure. Makes sense. And obviously, the key is that technical expertise is needed in that case, which the judge certainly ruled, Judge Cole ruled that it was here. So certainly makes sense. So Judge Peck, we've certainly seen Judge Cole demonstrate his frustration with parties on more than one occasion. Did you ever do so to that level of degree with some of the parties in your court? And if so, did it help them get in line to cooperate with each other better?
Well, if nothing else, it helped me avoid getting an ulcer, getting that frustration out there. So yes, I mean, I did do it. I tended to do it more in open court, on the record, when I was having conferences with the parties, as opposed to in a published decision. Whether that sort of venting was helpful to the parties, as with everything else with lawyers, it depended. Some of them got the message and cleaned up their act, and others, it just rolled off their back, and they just continued violating Rule 1.1, no matter how annoyed I was at them. One other point, if I may, using our may format here, and that is oral agreements are not worth the paper or ESI that they're not memorialized on. So for God's sakes, folks, if there is an agreement on something relatively important, like what is going to be privilege logged and what needn't be logged, get it in a stipulation. If you can't get it in a stipulation, at least send an email to the other side saying, we agreed at our last meeting to X. And if the other side doesn't write back and say, no, we didn't, you've got something to show the court later on. As Judge Cole was clearly annoyed here, there's nothing worse than one lawyer saying, oh, yes, we agreed on that, and the other lawyer saying, no, we didn't, and what's the court supposed to do with that?
Yep, that certainly can add to a judge's frustration and great point on that third dispute. So, and great advice. So, Mary, another key and interesting aspect of this case was that the defendant tried to use the common interest doctrine in protecting communications with two other outside parties, presumably with a common interest. So, what advice do you have for our audience on how parties can use the common interest doctrine to protect communications like those?
Well, I think it's important, as Judge Peck said, to document your joint defense or common interest early, certainly within your team, and know your jurisdictions, because it's different from jurisdiction to jurisdiction. So make sure your process follows the toughest jurisdiction, and continue to protect the privilege or work product by not disclosing outside of those who are in the agreement. And I can't emphasize this enough. Train the team, because normal people don't know about joint defense and common interest. People who are working in legal. So definitely train the team, and everybody needs 502D, don't they?
Ooh, 502D, what's that, Mary?
Yeah, and so protect your privilege that way as well, and make sure you do your logging appropriately. I would say this is probably not one to do categorical on immediately without an agreement. Yeah,
certainly, great points, and I obviously it was the nature of the question, but I'm shocked that Mary got to the 502D before Judge Peck did. So, but at least we got it in there for you, Judge Peck. So
I appreciate that.
Indeed. All right, so we'll move to the next case, which was also suggested by Judge Peck and inspires our first Yogi Berra reference of the day, deja vu all over again. We covered a previous ruling in this case back in February, where Florida Magistrate Judge Robert Norway had ordered defendant D. Donatus to turn over 3 electronic devices to defendant, USSSA, without copying any information from those devices. Issue resolved, right? Wrong. D. Donatus turned over the devices, but failed to provide login information or passcodes. So we're back to litigating on these devices. After being ordered to do so, USSA propounded several interrogatories seeking the information needed to access the devices. D. Donatus responded to some of the interrogatories by an objection that answering would violate his right against self-incrimination under the Fifth Amendment of the U.S. Constitution. After the court determined that D. Donatus does not have a personal interest in the devices or the ESI on those devices, it held that D. Donatus could not, as a custodian of USSSA's business records, invoke his personal Fifth Amendment privilege to prevent the collection and production of the ESI on the devices. The court also rejected D. Donatus's argument that the act of providing the information needed to access the devices would be testimonial and therefore privileged under the Fifth Amendment. And at least as to the iPhone he used and the laptop, but not the iPhone used by D. Donatus's wife, the court found that providing the information needed to access the devices would not be testimonial because USSSA could demonstrate through other means that D. Donatus possessed the devices, used the devices, knows the information needed to access the devices, and knows the types of ESI on the devices. So the court therefore determined that the foregone conclusion doctrine applied, and that granting the motion as to the laptop and one iPhone would not violate the Fifth Amendment. So the court provided 3 ways in which D. Donatus could comply. He could answer the interrogatories, provide the necessary information to USSSA's eDiscovery vendor, or provide the necessary information to another eDiscovery vendor. D. Donatus ultimately notified the court that he complied with the court's order by providing testimony about the information needed to access the laptop. He chose the third option regarding his iPhone, and naturally the parties couldn't agree on the vendor to use. So Judge Norway directed the parties to use one of 3 independent eDiscovery vendors he identified in the order, stating, if any of the vendors can provide the services needed and is willing to perform the work, then the parties shall use that vendor with all costs borne by D. Donatus. So Judge Peck, if the devices had been personal devices to D. Donatus instead of owned by USSA, could D. Donatus have been able to use the Fifth Amendment to avoid turning over the passcodes and logins? And if so, how?
Yes, the Fifth Amendment protects against incriminating yourself, and the case law has held that the act of production doctrine, that is, if you produce the computer on which negative evidence is installed, then you have you can assert the Fifth Amendment to not have to produce or not provide the password. And it's interesting, we all give up lots of rights by convenience, and it has been held that your thumbprint or your face, to use those methods to open a computer or other device, are not protected by the Fifth Amendment, but if it's a password, it is. So stop, for all the potential criminals in our audience, hopefully none, stop using, thumbprint identification to open your laptop or iPhone and insert a password code.
Yeah, very interesting that the passcodes aren't protected, but the biometrics are. Reverse that. So yeah, that is interesting that they're treated differently. So Mary, what could USSSA have done, if anything, to get to the devices, access to the devices sooner?
Well, one of the things would be right at the beginning in information governance, have the devices backed up to organizations' servers periodically so that the loss of a device isn't catastrophic. And then in an exit interview, there might be some incentives provided to return the devices. There are things like releases of liability, non-competes, commercial non-competes, non-solicits, those kind of things. And then when they brought that first successful motion, they might have included requesting the passcodes with a neutral expert validating that access was possible. And the passcodes could be saved under seal. The devices wouldn't have had to pass to the other side. But the idea that you have to keep going back and keep going back for the same ESI, I mean, it's just a lengthy delay, and it doesn't make sense to me.
You mean, Mary, the lawyers should have thought ahead in the first motion? What a shocking thought.
Now, did I say that out loud? I sort of did. Yes, I do think so. I mean, this is when I went to the Apple store to get my devices, they tried to like shame me into putting my thumbprint or Face ID on it. I'm just like, no, I'm doing passcodes. I'm just doing passcodes. And so I think culturally, I don't think we know about this. You know, in the larger community, and that would include most attorneys.
Yeah, no, I agree with that, and definitely agree with the several great suggestions to move things along quicker. And gosh, it's awfully tough for me to take away my Face ID on the iPhone, but I'll have to think about it now. So Tom, after all the delays getting to the information DDoS devices, what do you think the chances are that the devices will have been wiped or initialized when they finally do access them?
So in the ordering the production after all the delays and even attempts to, at one point, DDoS has tried to say, look, I won't give you the phone, but I'll give you a forensics image. We'll do a forensics copy and give it to you. The judge said, few things are certain in life or litigation, but DDoS can bet dollars to donuts that he has no choice but to turn over these 3 devices. And I think you can probably lay the same bet that something's going to be missing off those phones when they finally do open them up.
Yeah, I wouldn't be surprised at all. He's done everything possible to fight
Right.
to not turn them over. So I can't believe he just suddenly turned them over with all the information there intact. So
Yes.
It will be interesting to see. We may be covering this case again down the road with more developments on these devices. At least the 2 that ultimately he was ordered to provide the information for. So interesting case, and we will see what happens moving forward. In the meantime, let's go to our next case, which was suggested by an eDiscovery Today subscriber who's one of our regular webinar participants. Here, the Arizona District Court dismissed the plaintiff's case in October 2021 with prejudice under FRCP Rule 37E2 because it found he intentionally spoliated ESI. Burris appealed 3 aspects of the ruling of terminating sanctions and fees and costs of more than $296,000 in attorney's fees and nearly $67,000 in costs. Wow. So with regard to the first issue, the Ninth Circuit Court stated, Burris contends that the district court could not rely on the report without first conducting a Daubert hearing to qualify digital forensic specialist Jeffrey Englander as an expert in digital forensics. This argument is unconvincing. At the outset, because Burris failed to raise a Daubert challenge in the district court, he has waived any objection to Englander's qualifications. However, even assuming that Burris had properly raised a Daubert challenge in the district court, his challenge to the report's admissibility is meritless. District courts are not always required to hold a Daubert hearing to discharge their reliability and relevance gatekeeping duties under Federal Rule of Evidence 702. No finding of conflict of interest either, because Burris stipulated that J.P. Morgan pay for the forensic examination. The circuit court also denied the second claim that Burris did not violate 37E because the deleted documents were not relevant ESI, stating things like large volumes of ESI were lost. Burris was on notice that the destroyed ESI should have been preserved. The sheer number of obfuscatory actions undertaken by Burris evince an unusually clear level of intent to deprive defendants of potentially relevant ESI, and Burris had engaged in systematic efforts to destroy ESI from an array of phones, laptops, email accounts, and external storage devices. Regarding the third claim, regarding the court's authority to award fees and costs, the circuit court stated The district court awarded J.P. Morgan its attorney's fees and costs based on its inherent authority, which allows district courts to sanction a litigant for bad faith conduct by ordering it to pay the other side's legal fees. This was not error. It is well established that a district court may award attorney's fees and costs in addition to imposing terminating sanctions due to discovery misconduct. The court cited Burris's spoliation efforts and also rejected his claim that the fees and costs award was excessive. So, Mary, with the Ninth Circuit Court stating that district courts are not always required to hold a Daubert hearing, should parties still try to use that to question the credentials of an expert?
Oh, absolutely. I mean, it is the recognized standard, and then it should be used on some rules or case law in a particular jurisdiction say otherwise. The court has discretion, and so you have to hang your arguments on something, and it's a great framework. You don't need experts all the time in, for evidence. You probably don't need it for collection or simple undeletes or software generated reports that have been used in court previously. But for the more complicated stuff, the opinion stuff, the data reconstruction, you probably do need an expert. And you'd want to make sure they could qualify. Yeah, absolutely. So, Tom, the court ruled that over $296,000 in attorney's fees and nearly $67,000 in costs was not excessive. Doesn't that seem like a lot in a case like this? Tom, you may be muted.
Sorry.
That's right.
The number may seem high, but as you just pointed out, the court laid it directly to explicit deliberate misconduct which amounted to bad faith, which is clearly allowed under the standards. The court had even, if you read the case, the court had even issued a warning, and you talk about it here. He said, this is going to be coming if you don't tighten up what's going on here. And the appeals court said that all the attorney's fees the party incurred would not have been incurred except for the bad faith. So, yes, the number seems high, but the entire number is directly tied to the deliberate bad faith misconduct of the party. So, all I think, well justified.
Sure. Yeah, and ironic too that that Burris agreed to the forensic examination only if J.P. Morgan paid for it, and he ultimately is now the one on the hook for it. So funny how things work out there. So Judge Peck, go ahead.
I was going to say that is often typical. The party who thinks there was something improper going on in order to get forensic examination or whatever relief says, okay, we will pay for it. But if we find that the evidence, was spoliated, or we find X, Y, or Z that the other side said no to, then we get to ask for the fees to be paid by the bad guy.
Sure, which certainly seems fair. So let's talk about those fees for a moment. One of the keys here was that the district court awarded J.P. Morgan its attorney's fees and costs based on its inherent authority. Are there any guidelines as to when courts can use inherent authority to determine fees and costs and when they can't? And does it require bad faith for the court to base the award on inherent authority?
Of course, the answer is it depends. One should use the federal rules where applicable. So, 37A5 says the court must award fees if a discovery motion to compel is granted, or for the other side if it's denied, with certain exceptions. 37B, failure to comply with a court order also encompasses the court must order fees. 37E, it's more implicit in the rule than explicit. And look, anytime a party is caused to incur costs because of the misconduct of the opposing party is an easy call for awarding fees. The standards vary circuit by circuit. In some, it's bad faith, in some, it's willfulness. But as the old saying goes, I think the courts generally know it when they see it. And as somebody who is now a practicing lawyer, it is somewhat annoying when one spends X to prove the other side's misconduct, and the court gives you 80% of X or 50% of X, or as we just had in a case I was working on, the court dismissed the plaintiff's case, awarded us $1 million plus in legal fees, but it was only against the plaintiff and not the plaintiff's counsel, which meant it is probably uncollectible.
Well, that's unfortunate, but certainly interesting that the plaintiff in this case certainly wound up worse off than when he started, because he lost his case and now he's on the hook for $360,000 in fees and costs. So certainly a tough one there. And by the way, while this particular ruling doesn't get into a lot of the detail, people should consider looking up the ruling where the case was dismissed back in October 2021. It does really get into a lot of detail about spoliated ESI, and there was certainly no doubt that it certainly seemed to be clear intent to deprive, as the Ninth Circuit said here. So with that, we'll move to our next case, which is probably one that many of you are familiar with. It's the copyright infringement case by authors like comedian Sarah Silverman, who claimed that ChatGPT was trained on plaintiffs' works without their permission. So this ruling dealt with two plaintiff information requests. The first one was social media usernames for current and past employees and board members who've discussed anything relevant to the litigation. And the second one was information about individuals and entities who possess or have possessed stock or ownership interest in OpenAI greater than 5%. Addressing the social media request, California Magistrate Judge Robert Illman stated, "The court finds that the burden associated with undertaking this inquiry is minimal and that it's proportionate and responsive to the needs of the case. If all current directors and employees report that they have engaged in no such discussions on their social media accounts, defendants are ordered to certify that fact to plaintiffs, which will put the matter to rest. If, on the other hand, any current director or employee answers that inquiry in the affirmative, defendants are ordered to gather and disclose that person's relevant social media usernames forthwith." He ordered defendants to do the same regarding past employees, assuming the social media usernames were known to defendants. As for the request for information about stock-holding individuals or entities, Judge Illman stated, "The asserted basis for compelling this discovery appears to be purely speculative, as does the contention that the identities of these shareholders would help plaintiffs understand the defendant's corporate relationship and structure of relationship. Thus, the request to compel information pursuant to ROG number 14 must be denied because this discovery appears to be more in the nature of a fishing expedition based on suspicion and assumption rather than a request for discoverable material premised on concrete facts and assertions." So, Tom, do you agree that the request for information about stock holding individuals or entities with more than 5% of the stock was a fishing expedition?
I think it was more like a trawling expedition where you use these big giant nets to scoop up millions and millions of fish at a time. I don't know that calling it a fishing expedition does it justice. And the judge said it, you talked about some of it in the last paragraph there. There's nothing in the briefing that showed that there was any relevant information that was going to be produced. The basis for the request was purely speculative, based on suspicion and assumption, rather than any concrete facts and assertions. I don't know how much else the judge could have said to say, go away. There's just no basis for this whatsoever. So, yeah. I mean, well-based objection.
Yeah, he certainly left no doubt on that. So Judge Peck, so Judge Peck, given this is a copyright infringement case, what would an employee or board member have to discuss in their personal social media accounts for it to be relevant to the claims or defenses of the case?
Well, I think one of the issues is how was ChatGPT trained? And that's one of the major issues in the litigation. Apparently, it was trained on whatever is available by scraping data from the internet and, as well as entering books into the system and various other things. I'm not sure, why that would be talked about in social media if we're talking, typical Facebook public post, but social media could well include more direct messaging where the employees or directors could have been talking about how ChatGPT was trained by OpenAI. Ultimately, I suspect the issue is going to be, let me just stop. They could have talked about how, copyrighted material was used to train the system, period.
Right. Yeah. And certainly, it's this case is not over by any means, but certainly seems like so far an uphill battle for the plaintiffs, but it's never over till it's over.
That's a yogiism there.
That's a yogiism. I used it early. I was saving it for the last case, but I just threw it out there. So now I'll use it again when we get to that. But yes, indeed, we'll see what happens. So, Mary, we've seen a case before where a requesting party issued third-party subpoenas to individual employees for their mobile device data when the employer claimed that the data was in their possession, custody, or control, which the defendants did here with social media data. Could the plaintiffs do that here to ensure they hold those individuals accountable for any relevant social media activity in case OpenAI doesn't thoroughly check that activity?
Well, they certainly can, and the court's looking for concrete facts and assertions, and there's a lot of self-help that you can do with social media because there's publicly available social media, for many people that you can download with something like a page freezer or another social media collection tool. You can gather data from the people in your orbit, the friendlies that may have communicated with the people whose data you might be seeking, and then use some network analysis tools to determine who talks to whom, when, and about what. And then you've got your concrete facts and assertions. I don't think you can just, ask. I think you have to document why you want it.
Yeah. Absolutely. I agree. Couldn't agree more. So, and certainly we've seen a couple of cases where personal social media activity has been important to the case, like the moon emoji, smiling moon emoji case we covered last year. So certainly social media is a source of ESI that has to be considered in cases involving ESI. So, and we'll move on to our next case, which is our first of two cases dealing with hyperlinked files / modern attachments. And both of the cases were suggested by Judge Peck. So in this MDL involving allegations that Uber failed to implement appropriate safety precautions to protect passengers, which led to alleged incidents of sexual assault or harassment by Uber drivers, the parties were dealing with cloud-stored documents issues, particularly as they relate to Google Workspace, which Uber uses, as well as metadata fields and related provisions of the ESI protocol that the parties were trying to agree upon. California Magistrate Judge Lisa Cisneros framed the issues by stating, of principal concern here, a Gmail or Google Chat message that contains a hyperlink to a document is referencing a Google Drive document that may still be evolving. A recipient or others may modify that reference document, which is centrally located so multiple people can access and edit it. Furthermore, Google Vault does not export, collect, or connect the contemporaneous versions of hyperlinked documents with the corresponding emails or messages in which they are found. Certain technologies have been developed to link email and chat messages to Google Drive documents, but there are limitations. Yet, contemporary versions of hyperlinked documents can support an inference regarding who knew what when. An email message with a hyperlinked document may reflect a logical single communication of information at a specific point in time, even if the hyperlinked document is later edited. Thus, important evidence bearing on claims and defenses may be at stake, but the ESI containing that evidence is not readily available for production in the same manner that traditional email attachments could be produced. Some of Judge Cisneros' rulings on the issues were that Uber shall preserve the metadata relationship between email messages with links to files on Google Drive to the extent feasible with existing technology, as well as all metadata collected. Producing parties shall make all reasonable efforts to maintain and preserve the relationship between any message or email and any cloud-hosted document hyperlinked or referenced within the message or email. Uber shall produce, to the extent feasible, on an automated, scalable basis with existing technology, the contemporaneous document version, i.e. the document version likely present at the time an email or message was sent of Google Drive documents referenced by URL or hyperlinks therein. And perhaps most notably, attachments shall be interpreted broadly and includes, e.g. traditional email attachments and documents embedded in other documents, as well as modern attachments, pointers, internal or non-public documents linked, hyperlinked, stubbed, or otherwise pointed to within or as part of other ESI, including but not limited to emails, messages, comments, or posts, or other documents. This definition does not obligate Uber to produce the contemporaneous version of Google Drive documents referenced by URL or hyperlinks if no existing technology makes it feasible to do so. Yes, he called them modern attachments, and this is a case you should definitely check out, as there's a lot more information related to this case that didn't make it to the slide. And certainly this is a case that had already inspired some questions, so we'll certainly work those in. Questions and comments. But first, let's go to our panelists here. Judge Peck, technical issues associated with production aside, do you generally agree with Judge Cisneros that attachments should be interpreted broadly and include hyperlinked files? Judge Peck, are you muted? Did we lose Judge Peck? Can y'all hear me?
We can hear you, Doug.
Yeah.
Oh, okay.
Sorry, that's what happens when I went on mute before to avoid the heavy construction traffic outside. The part of your question that says other than technological issues is like saying, other than that, Mrs. Lincoln, how did you like the play? That is the major technological issue we're dealing with nowadays. If it were not difficult to produce the linked documents, yes, I think that they are part of a document family, whether you call them a link or the dreaded modern attachment term, which Gareth Evans already said in the chat, that they're not attachments, modern, ancient, or otherwise, and I agree with that. But yes, they are part of the family, and if it is feasible to do on a commercially responsible basis, then yes, they should be kept together. The feasibility question is the big issue here and in our next case.
Yep, indeed. So Mary Judge Cisneros relied on the Shenwick v. Twitter case from 2018 to decide that the plaintiffs could request up to 200 hyperlinks for which they seek the contemporaneous reference document. Does that number seem arbitrary, and isn't there a better way to determine how many documents the plaintiffs can request?
Well, it's certainly arbitrary, but you could probably sample things or do other things. And I agree with Gareth about the hyperlinks aren't necessarily attachments. They are hyperlinked and hyperlinked documents. But I think it's not historically accurate to call this a technical impossibility. We've had this kind of technology since the Xantaz days with stubs and hyperlinked documents. We've had versions since Documentum days. So it's not an unknown. It may be difficult, but it's not an unknown.
Certainly interesting. And as Gareth noted, Gareth definitely has a lot to say about this case. In the end, the court only ordered the defendant to manually collect up to 200 hyperlinked documents. So certainly, I think the court was discussing the challenges and trying to provide some, kind of approach for the evidence to be produced and collected to the extent possible. So Tom, one of the things producing parties keep saying is that it's burdensome to collect hyperlinked files and treat them like attachments. So what do you think they should be required to show to demonstrate that burden?
Oh, just give me a break, huh? From the recipient's point of view, this talk about it's too hard for me. What they're saying here is that they can't hit the easy button and do it automatically. As Mary said, there's ways to do this. There have been ways to do this for quite some time. And I think we're also looking at, and as Judge Cisneros pointed out, these people chose Google Vault. That was their decision to choose something to make it difficult to do. But I also think we're looking at it too far down the road here. It's more difficult at the time of production because the documents may have been changed depending upon where they are. And remember, saying that they're hyperlinked isn't really enough either. Are they hyperlinked to an internal system like iManage, or are they on a outside web-based system? You got to have some sort of a showing about what you mean when you say it's too difficult. But really, I go back to why wasn't that done when the emails were preserved? Okay, when did the duty to preserve arise? And if the duty to preserve fell to the email, why did it not fall to any document that was involved in the email? I don't care if it's an attachment or a hyperlink or a reference to a web page or whatever. You should have preserved it then. So I'd want to look at, if I were the receiving party, I'd want to look at when did the duty to preserve arise, and how much later was it that you decided to preserve and or collect? What was the degree of difficulty then?
But Tom, I think the question is preserve it or preserve it in a connected fashion. One could have preserved Google Vault, could have separately preserved the active emails, not necessarily preserved marrying it all together.
I'm not suggesting that they marry it all together. I'm suggesting they go out and get the document and preserve it. And saying that they can't do that automatically is disingenuous.
I agree, Tom. In fact, that's one of the things when I wrote last year about and provided kind of 5 assumptions. One of the things I said is, regardless whether you can create that link, those files in those archives should still be preserved and produced if they're responsive.
Yes.
So you may or may not be able to tie them, but those archives should still be searched.
Yes.
So I couldn't agree more with that. And certainly a couple of comments I'll get to. Obviously,
we've hit a nerve here, Doug. We've hit a nerve.
We've hit a nerve. Now, a couple of these comments, as I read them, I realize aren't necessarily about this case. So we will get to those here in a bit. But Gareth also pointed out that we're overlooking the fact that the judge accepted the defendant's showing it wasn't possible to automatically associate and collect the concurrent version because it wasn't technically possible. I thought we kind of made that clear. I think she was kind of recognizing the technical challenges and the inability to do it, but at the same time saying that they should do it to the extent possible. But if we didn't make that clear, I certainly would say that I think the judge did make that clear. So a couple of other comments here. Let's see. Well, one question: provided that the versioning system used by Google Docs and similar online storage locations lead to the spoliation of ESI because previous versions can't be reconstructed, must data be collected from those systems as soon as the duty to preserve attaches? I certainly think that's something to that is. I think that's. Certainly, I think what you were saying, Tom, you were talking about that as being something that, they should be collecting, once the duty preserved, they should be preserving at least and making sure that those files at that point are still available. Obviously, you can't do anything about what happens before the duty to preserve attaches and evidence that may no longer be there, but certainly it changes the stakes once the duty to preserve attaches. So certainly do, I would say that's true. Comment here, people choose their mail systems based on business need, not for litigation purposes. Certainly true, but on the flip side, the requesting party might argue, yes, but does that mean I shouldn't have access to the evidence that, ties into the case? So,
I would just add, it's one thing if they try to come up with some cockamamie workaround for business purposes, but if you're using Google or Microsoft, the two biggest platforms around, and that is a reasonable system to use for business, the fact that it creates problems for litigation later can't really be held against the person, in my view.
No, that makes perfect sense. So yeah, there's certainly a couple of other comments here. Microsoft, you have to set up your tenant a certain way in order to preserve contemporaneous copies. So that isn't that a business decision that should not be driven by potential litigation. Certainly, that's what Microsoft has talked about with their cloud attachments feature. But I've also heard some people say it's not as robust as it could be. Certainly,
but it's there and it works. There have been statements, and we'll see it in the next case, that there are no solutions out there. And as Mary pointed out, there have been, and there are. Are they elegant? No. Are they under development? That's the real problem, isn't it? That technology is just racing ahead of us here. The Microsoft Purview solution to this kind of went active, I suspect, during the time at which Judge Cisneros was getting briefs on this issue. So, we're in the middle of these discussions and cases or technological advances are popping up. So that just makes it a real headache for judges.
Sure. And of course, this case dealt with Google, and I think it's well understood that Google doesn't have the advanced capabilities of tracking the contemporaneous versions. So these are certainly all challenges. And hey, since we're into this discussion, why not get into the next case where we can just continue the discussion? And certainly we'll be happy to stay a little bit beyond to address all these questions and comments. And hey, just when we thought we were out of the R hyperlinked files modern attachments debate, this case pulled us back in. Over a year ago, California Magistrate Judge Thomas Hickson granted the plaintiff's motion to compel and ordered the defendant to produce the linked documents as agreed to in the ESI protocol, saying things like, this order is about agreements, and when parties reach an agreement, we ordinarily need to hold them to it. Litigants should figure out what they are able to do before they enter into an agreement to do something. Litigants should live up to their agreements, especially when they're embodied in court orders, as the ESI protocol is here. A year later, never mind. Judge Hickson now says the ESI order states that it may be modified by the court for good cause shown. StubHub has demonstrated good cause to remove the requirement that hyperlinked documents should be produced as if they were attachments to emails. StubHub has made a persuasive evidentiary showing that despite having spent hundreds of hours trying to find linked documents and despite having retained an outside eDiscovery vendor to assist with this effort, the hyperlink requirement is technologically impossible to fulfill most of the time. He also rejected 2 expert declarations from the plaintiffs, including one where one of the experts said it might have been possible for the defendant's vendor to find a hyperlinked document more than 17% of the time, which isn't even a good batting average in baseball. He also added, in response to StubHub's reply, that there is no out-of-the-box program that StubHub could have purchased and run. The court thinks that the non-existence of commercially available software that can implement the hyperlink requirement tips strongly in StubHub's favor. So he struck the language, hyperlinks to internal or non-public documents, as well as and email or other documents together with any documents referenced by document stubs or via links to internal document sources within those emails from portions of the ESI order. And he denied the plaintiff's request for sanctions under FRCP Rule 37b2, Inherent Authority, and Rule 26G. And this is where I was going to add in my, as Yogi Berra would say, it's never over till it's over, because it certainly isn't in this case. So Mary, given that Judge Hickson has allowed StubHub to modify the ESI order with good cause, does that change the motivation for parties to fully understand their data before agreeing to an ESI protocol where they can leave themselves an out if they can't comply with it?
Well, it very well may, but I think this is just well, you know how I feel because I told you about it in the last case. It is a challenge for a service provider or a platform to keep up with the changes in emails and how things are connected. We're living in an agile environment where things are released every couple weeks. And sometimes, for example, when Zylab was able to do the emails and the attachments out of Google Vault for a client in California in 2015, they got it. They did it, and then Google changed its authentication method, and they had to go back and jiggle it around so that they were able to do it again. So it's not easy. So I do think it will change people's calculus about entering into protocols when the two platforms that have probably 80% of our data, Google and Microsoft, that there's an out for them. That does not make sense to me. Right.
Yeah. And obviously, one of the things that was key here is that the ESI order did provide an ability to modify for good cause. So that's certainly something that I think we'll see in pretty much every ESI protocol in order going forward for parties to kind of give themselves that out. So certainly will be interesting to see. Yeah, go ahead.
And just to note, I mean, in the prior decision, I mean, this is not Judge Hickson changing his mind or whatever. In the prior decision, there were several references to StubHub never moved to modify the ESI order and therefore the prior ruling, et cetera. Right. I think there were at least 3 such comments. So on the other hand, in terms of that, sort of escape clause, there have been discussions of those escape clauses about, TAR protocols and ESI protocols and everything else. And some lawyers, because they want to trap or keep the other party from getting a change from what was agreed on, won't agree to that modification clause. So it's, balancing what's good for you versus what's potentially good for the other side.
Right. Which is why we're seeing more disputes about the ESI protocols and orders now, because they can't even agree on that. So Tom, Judge Hickson certainly put a lot of weight into the fact that there's no commercially available software that can implement the hyperlink requirement. So given how often solutions to eDiscovery challenges start with workarounds, does this seem like a valid assumption to you?
Well, regardless of workarounds, I just don't think that that's accurate. Microsoft Purview Premium allows you to set up retention labels, which will grab the documents if they're being stored in SharePoint or OneDrive, either SharePoint or OneDrive. And they'll label those attachments, preserve them, as soon as the document is sent, and they'll grab the subsequent changes if the documents are changed. Now, as Sam Huff just mentioned, it's sounding like I'm advocating for that feature to be turned on. Well, I am, because I think it just saves you a lot of heartburn later on. But I don't think you should be arguing that it's so horribly difficult that it can't be done, or there's nothing out there that allows you to do it. There are workarounds, as Mary described, going way back. And even Judge Cisneros in her brief mentioned, the effort by Lighthouse, the eDiscovery company, to build something for Google Vault, and Peck, right? There are 2 tools under development now. You have to believe those are going to come to fruition by the end of the year. So again, the speed with which the software is changing this whole environment. I think Judge Peck made the best point was, it's a policy decision. If you've decided that this is what you're going to use and you stick to it throughout all of your cases, throughout all of your company, and you've done that since, time immemorial, or at least since the time Google Vault came along, then that's it. That's your document retention policy. And so I think, you've got a little bit of a basis for saying, if you're going back several years with that policy, to claim it. But the talk about it's too hard, it's too difficult, it can't be done. I just don't believe that.
Okay. Well, certainly one of the things we've talked about, of course, with there being Microsoft and Google as the 2 primary sources of this information, one thing that I had forgotten until I put this case out on LinkedIn last week is somebody reminded me that this was kind of a hybrid kind of approach, where it was basically emails and Microsoft pointing to Google Documents. So it wasn't even it wasn't a total one provider solution, which further complicated the challenges, I think, certainly in this case. So Judge Peck, do you think decisions like this one can impact other cases going forward, or will each case be dependent on the technology capabilities at the time it's decided for the foreseeable future?
There is too much risk that a court will look at this decision, or the Uber decision, or going back a year or almost 2 years, Judge Parker's Noom decision. And if that's all that the parties cite, or that's all the law clerk for the judge has found, and the judge is not within the discovery bubble, you may follow the wrong case, or a case that was right at the time. But as Tom and Mary pointed out, the technology is changing much, much faster than judicial decisions. So it is incumbent on the parties in the first instance to properly educate the court on what has changed since the last decision dealing with hyperlinks, or dealing with anything else in the discovery sphere. And also to be careful with what experts, we had the question about Daubert earlier today, what expert you're going to listen to. The plaintiff's expert here and in the Uber case, same expert on the plaintiff's side, Doug Forrest, and he was citing to the court this proof of concept that he found somewhere on the internet, and was trying to sell that as the solution to be used in these cases, and the court fortunately was having none of it. And just one last comment on the escape clause from protocols. It is a good idea, but again, parties should know what they can and can't do before entering into an ESI protocol. StubHub got lucky in this, redo, where they were able to use the modification clause to have a different result. But, assume the worst case is going to happen. If you agree to something in an ESI protocol, assume that the court is going to hold you to it. So make sure to think properly about what you're willing to agree to before you have to exercise the good cause modification later on.
Yeah, absolutely great advice, and certainly a couple of very interesting cases. So while I move to the contacts page and point out that our next case law webinar is a mere 18 days away on Manic Monday, June 17th, let's clean up a couple of our comments and questions from earlier. So let me kind of go in reverse order here, since a couple of these I think tie to the last couple of cases. So certainly one of the points one of our audience members mentioned is that many links to files and documents provided in an email are in the form of a generated hash at the end of a link, not the file name, and links are also sometimes set to expire. So yet another complication, and a good point that adds to the mix here. So appreciate that comment here. And then, of course, one of our audience members mentions the fact that if you with some of the purview capabilities, only if you process in purview, and then you may have later processing issues. And that's one of the things I've heard is some of the challenges in purview are still kind of making the eDiscovery challenges of purview are overriding some of the preservation and retention capabilities in terms of some challenges there. So I have definitely seen a lot of that. And then a question: if litigation starts in 2023 and earlier emails have links from 2021, no duty then, correct? Well, it depends on the retention policy, but certainly if the retention policy is such that those emails happen to have disappeared before that litigation starts, they're certainly not a part of the duty to preserve. Any other thoughts or comments on any of those observations or questions?
Duty to preserve doesn't start on the day of litigation.
No, of course. No, of course. That's a great point. Yes. Yeah, it should. I would say the question should have read if duty to preserve starts 2023, because yes, it could start considerably before the date of litigation. Great point, Tom. All right, a couple of other.
I'm sorry, I interrupted you, Judge Peck. You had something to say.
Except I now forget what it was.
Okay, no worries. A question from one of the earlier cases. If it's the company's social media, it's in their possession, custody, and control. But when it's personal accounts, is that really the case? Surveying or interviewing your employees to certify the response, I understand, but I'm not sure personal accounts are within the company's possession, custody, control, unless internal policies regarding posting about work state that they are and provide employees with that expectation. So any thoughts about that? I guess what I think it looks like what he's saying is that, are they really required to provide the information regarding those personal accounts? Any thoughts on that?
I think it depends on whether you're in a practical ability, possession, custody, or control jurisdiction, or a legal right. The company wouldn't have the legal right to that information, but it might well have the practical ability to get it. I mean, the other question, of course, is how valid is the survey? Gee, do you have any email or social media where you're talking about, stuff relevant to this litigation? Generally, the answers to that are no, and that may not be true. So the judge was, I think, very light on what it was requiring to be done there.
Right.
Yeah, absolutely. Couldn't agree more. And the last question, which is, considering the cases discussed today, would any of the speakers futurists like to opine on the future of social media and AI's impact on our lives today? Nothing like ending with a broad question to consider there. Any of you have any thoughts on response to that question?
I would just say that our friend Ralph Losey keeps saying we shouldn't have humans on these panels, we should have robots. So who knows?
Yeah.
Indeed.
Yeah. Robots, yeah. Klaatu, Barada, Niktu. That's what I got to say about robots.
Yes, maybe we will have to have a whole nother webinar on a topic like that at some point, because that's a meaty topic for sure. One last question that just came in: do you think we're going to see decisions that come close to mandating companies that use technologies that preserve contemporaneous copies, even if the business does not find value in keeping such copies? Essentially, you have to set up the retention tax because it's possible. Any thoughts about that?
Oh, I don't think so. Do you, Judge? I mean, courts aren't going to order that.
Unlikely. The court's authority is limited essentially to when there is litigation. How the company does its business is not within the court's authority. Sure, if we had a functioning Congress, maybe they could do something, but we don't.
Let's not go there.
So, there will likely be a decision in one of these areas that says you chose to make it hard on yourself. Okay, you've made it hard on yourself, but you still got to do it. Yeah. But further than that, no. It would be sort of like saying, okay, everyone has got to get a license for Microsoft Purview, has got to get a paid highest license for Slack, et cetera, et cetera. The courts are not going to order that across the board.
Nope, I wouldn't think so either. And it's going to be interesting to see. Obviously, this topic has generated a lot of discussion out in the legal arena, and we'll certainly be interested to see how the case law continues to evolve here and how the technology continues to evolve. In the meantime, thanks to all of you for attending today. As I mentioned, our next case law webinar is on Monday, June 17th. So with that, I will say thanks to Mary, Tom, and Judge Peck for their terrific insights as always. And I'll turn it back over to you, Mary, to close us out.
Thanks, Doug. And we thank you for anchoring, of course, and the great Tom O and the Honorable Judge Peck for this very lively presentation. And I want to do a special shout out to Craig Ball and Michael Berman, who've been blogging on this issue along with you, Doug, the modern attachment issue. Our thanks to the EDRM community for your kind attention, for your great questions. And if you really love this presentation, showed the Honorable Judge Andrew Peck, Tom O, and Doug Austin from Houston some love, find your emojis at the bottom of your console. And to be automatically registered for on-demand webinars, click the pop-up at the conclusion. Once there, click the bell to subscribe for future updates. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everybody.
Thanks, everyone.
Bye, all.